Well, hello everybody. This is March 15th, 2017. My, how time flies. And this is the first of our nuts and bolts programs for this year in the Step 2 program. And of course there are four. This being the first one is the overview. So our agenda today is going to be approximately an hour. Could be more, could be less. On the side panel of your screen, you can put in chats, and they will pop up, I believe. But you're all unmuted at the moment, so feel free to interrupt if you have a major question. And so why don't we get started? So this is the introductory overview of our family education program, and the program really has three parts. There is the trustee training preview, which is a preview of our trustee training program. That's actually going to be in two parts itself. There are two sessions, the nuts and bolts of estate settlement and the nuts and bolts of disability. So that's trustee training in and of itself. And then there's we're going to go over the client orientation meeting summary, which is really a more general understanding, to give everybody a more general understanding of what our program means and what it's all about and why we do what we do. And then at the end, we're going to tell a nice story that's going to kind of illustrate what really happens when somebody dies. So we'll go ahead. So there are four separate training classes. There's the one tonight, there's one on April 19th, then there's one on September 13th, and one on October 14th. The resources are, of course, our webinars. If you go to hdlawgroup.com, you'll be able to sign in to our website. I'm just going to show you that briefly. This is where you can sign into the Step 2 programs member page. Now, I just want to, as an aside, say that soon you will be able to go to heritagedesignlaw.com, which is our main website, but right now that's under reconstruction. I hired a new company to build the site, so that's in the process. But in the meantime, the main place that you went when you clicked the button was right here to hdlawgroup.com, and when you can sign in, you sign in right there. And of course, the sign in is, the username is step 2, and the password is member with a capital M. So let me go back to our slides. There's really three basic parts to really the whole family education program. The first part, and the one that we've been doing the longest, is the wealth transfer training part. And that's the nuts and bolts of disability and estate settlement. More recently, we began to look at, as a national network, we began to look at estate planning from the recipient's point of view, and began to realize that it was important for us to consider in the planning how these plans actually operate and how they influence or how they affect the recipients, meaning the beneficiaries of the plans. So the words wealth reception planning came into view. So we were planning with the recipient in mind. And then the third is to actually support the recipients themselves. So part of our program is to teach the recipients about what it's like to be a beneficiary of a trust or an estate plan under our system and how things work like that. So I'd like to talk a little bit about one of the basic principles of the national network, which is the whole idea of time to think. This is a concept that was introduced by Nancy Klein a few years ago in a book that really has kind of revolutionized the whole meeting idea. It's based on the idea that everybody does their best thinking when they are actively listened to. So if you are actually planning to try to voice your views in a meeting and you anticipate that somebody's going to interrupt you, they won't get your best thinking. But if you know is an absolute thing that you are not going to be interrupted, that people are going to listen to you and hear what you have to say, you're more likely to talk freely and to actually allow yourself to think through the problem that you're discussing. And so what's occurred over the last few years is that the whole concept has been taken over, has been brought into the corporate world, and they found that their meetings are far more productive and creative. So the network actually uses the whole concept both in the network itself and also in our meetings with our clients. So the whole goal of the idea of Time to Think, which was the name of the book, is to get your best thinking. And we like to get our clients' best thinking in our planning, and we like to get the participants in our plans' best thinking so that they can tell us what they really think about what they need. So one of the concepts from Time to Think is something called the limiting assumption, which is the, like I was talking about before, it's the sort of assumption that if you're in a meeting and you're trying to express your views, you're going to most often be operating on the assumption that somebody is going to interrupt you, and that's going to limit your ability to actually express your best thoughts. And limiting assumptions abound in people's outlooks on various different topics. So for example, in the estate planning field and estate settlement, law firms typically operate on the limiting assumption that we are only going to get to see you once. We're only going to get one chance to see you. That's the old traditional transactional mentality where people came in, they did their planning, and then they were gone. And then some years later, they might do it all over again. But the law firm felt that they were only going to get one chance to see the client, and so they had to do everything together, and that was a transaction. That's a limiting assumption. Helpers and receivers of wealth also have limiting assumptions. For example, the assumption might be that it's going to be a negative experience to talk with the person who you're a beneficiary of about their death or about their disability. And it also might be that it's going to look like you're greedy to ask them about their assets and tell them what you want. Those are limiting assumptions. They prevent people from actually talking about the issues. And so the questions that actually get asked in order to liberate people from those limiting assumptions. So for example, the law firm, if they were asked, what would you do if you knew that the helpers and receivers would see the benefit of active planning participation? Well, the answer to that is I would try to create a program where they have the chance to learn about it and to actually participate in the planning or in how it actually gets implemented. And if you're a helper or receiver, what would you do if you knew the plan creator or the person that you're a beneficiary of values smooth transitions, and that advanced discussion is key to that? Well, then you would want to have those conversations, and you'd want to have that training. And so that's really the source of what our whole family education program is about. It's developed around the whole idea that we shouldn't make the assumption that people don't want to learn about this, that they don't want to talk about it, that we should give them the forum and the ability to learn and to talk and discuss and encourage them to discuss amongst themselves. So there are 4 nuts and bolts programs. The first one, of course, is the overview and the werewolf story. That's today. The next one on April 19th is called Death Settlement. That's about settlement on death, of course, estate settlement. The third one has to do with disability settlement and what's involved with healthcare proxies, representatives, successor disability trustees, and that kind of thing, which most people don't really think about when they're thinking about estate planning. They think that has to do with what happens after you die, but really planning does mean a lot more about what happens when you're alive as well. And then the fourth nuts and bolt program in October is designed primarily for the recipients of wealth, and it's about how to maximize the value of your inheritance. So, what are the goals for our program? Well, of course, it's to make it smoother and easier for those that follow. So, I'm going to give you a bit of a preview about our trustee training workshop. This is a short preview, but it's a preview nevertheless, so that you understand basically what we're trying to get to when we have those programs. And essentially, there are 4 goals of these programs, 4 fundamental goals. One is so that you know the law firm name and our contact information, which is important, of course. Second, but even more important, and that is that you should remember that there is a process, which we're going to teach you, and it's the process that produces the results that our clients wanted. So we need to follow it. You want to also give people who are going to be the helpers or involved in estate settlement an idea of the types of issues that they're going to deal with when somebody dies or becomes disabled. And we also want to, of course, encourage interest and participation in the planning. So your 911 info about what happens when you need to dial 911. Well, the first thing that people are supposed to do is, of course, to call our law firm. And then the second thing is to locate the helper's handbook. This is what we call the Blue Book, and it's the book that talks about a lot of how we deal with the assets and how we deal with our relationship during the maintenance program. The third thing is to locate the client's red book, which is where all the documents are. And the fourth thing is to relax and remember that there's a dependable process to follow, which we do teach you during the trustee training program. So our goal for the program is that we can get you to share with us. We want people who participate in the program to call us, and I should say that anybody who attends one of these programs has the ability to call us anytime and ask us about the planning that they may be a part of, to the extent that our clients will allow us to disclose it, and most of them will, because you're on these programs. We'll explain how the process goes and that kind of thing. Or you can send a private email. But let us know what's working and what's not working. So, we want to encourage those things in our program. So it's also important to remember that there are 4 pillars to an estate plan, and this all comes out of a study that was done by Allianz Insurance Company a number of years ago. They did a survey or a kind of a census of people who were in the older generation, and at that time the baby boomers, were the younger generation. Now it looks like we're getting closer to the older generation, but then we were the younger generation, and they asked the older generation what they thought the younger generation felt was most important in their planning. And then they asked the younger generation the same thing. And the older generation, of course, came out, they thought the most important thing was their financial assets and their real estate and how that was transferred. But the answer from the younger generation, and I think this is probably pretty general, is that they were more interested in knowing the stories about the people that they would inherit from. And that's kind of illustrated by the fact that most people, or most probate claims or probate contests, have to do with specific items of personal property. For example, mom's ring, dad's guitar, the knife that dad brought home from World War II or something like that. And it's the values that people can transmit and their lessons that they've learned during their life uh, that they found the younger generation was most interested in. Then they wanted to know what the instructions and wishes were that were to be followed, particularly with regard to burial and that kind of thing. Then, of course, there were the personal possessions of emotional value, because those actually tend to represent the personality and the memory of the person that we lost. And then finally, their priority was, the fourth priority was really the financial assets and real estate. So the financial assets actually were less important than the first three. And the result of that was that in the estate planning field, we began to look at trying to help our clients communicate their values, their lessons, their stories, their instructions, as well as their financial assets and their real estate. So also what that's resulted in is something called wealth reception planning, and I mentioned this a little bit earlier. And what that is, we've kind of come to a definition of this in the national network, and that's a formal process designed to assure you and your loved ones that your true wealth, both your financial and non-financial, is fully realized, effectively transferred, and efficiently transferred and effectively received. So, you know, we do try to do the estate planning, of course, and we do the estate planning for our clients, but part of it now has to do with wealth reception planning, to take in the whole picture of what happens when the people who actually receive the wealth actually get it. If you think about it from a football point of view, if you're the quarterback and you're doing your own planning, and the beneficiaries are the receiver, well, you've got to do a lot of training with the receiver in order to have a successful game and actually to complete passes. So that's really what wealth reception planning is about. So that's really where Nuts and Bolts 4 comes from. That's the program in October, and that's how to maximize the benefit of your inheritance. So now what I'd like to do is to talk a little bit about the whole basis of our program, where it comes from, how it got developed, and what the concepts are that are behind it. And the fundamental concept behind it is that most estate plans just don't work. Our clients will probably recognize those words. Many of them have heard that. We have a number of clients who came in through a workshop, and they've heard that too. And you know, we repeat this at our annual client meetings as well in some respects. And most estate plans don't work. And the reason that they don't work is because they don't meet their expectations. So what does that mean? Well, if you die and you're up in the clouds, which is the better alternative, looking down, if you're up in heaven looking down and watching what people are doing, and based on your estate planning and your instructions, if they're running around doing the kinds of things that you expected them to do and not doing the kinds of things that you didn't expect them to do, then that's a plan that worked. Anything else is not acceptable. That's a plan that doesn't work. So the snapshot test is really all about, well, what is a person's vision about what actually is supposed to happen? What are people supposed to do after they die? And our job as attorneys and estate planners is to help our clients to kind of bring all of that into focus, so that we can help them put together their instructions to make their plans work. And part of that has to do with what's the target. So the network has this definition of estate planning, which is, I want to control my property while I'm alive and well. I want to plan for me and my loved ones if I become disabled, and give what I have to whom I want, when I want, and the way that I want, all while assuring that my wisdom is transferred along with the rest of my wealth. That definition is really essentially, it's a target for someone to look at. Okay, I've got this vision of what's supposed to happen, but in order to make it actually more concrete, I need to have a definition of one of the various different issues that I've got to face and deal with, and that's what the definition of estate planning is all about. So we also have something called the estate planning pyramid, which helps people understand the priorities that they're supposed to be following. And so if you were going to build a pyramid, you would start at the bottom. The most important rung at the bottom is the base. And in estate planning, that is actually the person who's doing the planning. So if I'm doing the planning, that's me. It's important for the attorneys to understand who I am and what my thoughts are, what my experiences are. And then after that, they need to understand what my family is. And so I can teach them about my family and who they are and what their strengths and weaknesses are. And then after that, most of attorneys actually spend most of their time dealing with the issue of preserving wealth, to make sure that people don't lose it, or to help our clients prevent people from losing the wealth that they transfer to them. But of course, if a client can preserve their wealth and they're satisfied with that, and they've got the opportunity to expand wealth, then they're going to try to talk about that too. And that's why we work with financial advisors, because they concentrate mostly on expanding wealth. And then finally, there is saving taxes, which is what we call the easiest piece of the puzzle. If oftentimes we ask the question in a group, what's the easiest piece in the jigsaw puzzle? And most often attorneys, when they're asked that question, will say colors and corners. Engineers sometimes say that too. Financial advisors do as well. But clients often answer, well, the real easiest piece in the puzzle is the first one. Or sometimes the answer is the last one. And the last piece of our puzzle is saving taxes. But, you know, attorneys are trained to deal with the tax issues. So oftentimes what happens is that when we do planning, we start with saving taxes and don't really get to the rest of it. So it's important to understand that the planning pyramid really helps people understand what the priorities are, where we're going in terms of what we're trying to do. It focuses on the client's goals, not on just taxes. Taxes are easy to deal with, at least in the base planning area, and it helps us make solutions that make planning easier, and it exposes traditional planning, which is transactional planning that we mostly, and I'll confess I used to do. It's kind of upside down, starting with taxes and not really spending time with what's important to the people that we're planning with. So we found that there are really four keys to an effective estate plan. The first one is personalized counseling. So you've got to have it's important for you to actually be able to speak about what you think, to find out what the options are. And if you don't know what the options are, and you don't get counseling on what your options are, you'll never choose an option that you're not counseled about. And so you need to know what your options are in terms of the various different things that you can do in your planning. And that's why it's important to have counseling. And the second, of course, is proper asset ownership. You can have all the counseling in the world, but if you don't line your ownership of your assets up with your counseling, with the instructions that you left behind, then your plan's not going to work. As an example, if I did a trust with 120 pages, spent a lot of time on it, put all my instructions in it, and then had all of my assets held jointly with my wife, well, none of those instructions actually operate on the assets that I own. And then, of course, there's a formal review process, is an important key, which means that, what I like to explain is that there's a lot of changes that occur. People's personal circumstances change, financial circumstances change, and what most people don't think about is the fact that lawyers' understanding of their clients' needs and their ability to develop new solutions also changes. So in the network, we get together every 6 months to talk about things that we've learned, to share our knowledge and our expertise. And a lot of times our clients teach us new things because they ask us for new options, which we work out. And so if you were going to take a choice between a plan that I did 10 years ago and did my best job on, put all the bells and whistles in, and the one that I would do for a person today, which one would you pick? Well, you pick the one that was today, which means that, it's important if you did the one 10 years ago, it's important for you to have a formal review process so that you can update it based on the changes in the law and changes in your personal circumstances and the changes in the options and types of things that I can offer. And then finally is a controlled transfer process. Because, if someone dies it's important to know what to do, how to do it, and how to pay for it. If you went to an attorney and you did normal estate planning and asked them how much is it going to, are you going to charge me to settle my estate, they're going to have to say, I don't know, because they don't know what you're going to have. In our program, we are able to come to a determination of what that is because of the updating program. We make sure that everybody updates their assets with us, so we know what they're going to have, so we don't have to do that morbid scavenger hunt and look for everything. So that's important. That's part of the review process. But you have to know what to do and how to do it, and that's part of the training. If somebody dies and you haven't had any of that training, and you walk into a law firm's office and you sit down and you ask them, okay, so what has to happen? You're talking to the most expensive teacher you can find. And if they tell you how much they're going to charge you, you have no reference point to know whether that's a reasonable fee. You need to know what to do and how to do it and what has to be done in order to understand whether that fee is reasonable. And so controlling the transfer process is an essential element to an effective estate plan. So we developed a three-step strategy, which is to develop your plan with counseling-oriented planning partners. That's the first step. Commit yourself and your family to a formal and continuous maintenance and education program, and secure appropriate assistance for you and your family to transfer your wisdom along with the rest of your wealth. That's step 3. So in the counseling area, traditionally there are 3 types of estate plans. There's married couples that have under the federal estate tax threshold, married couples over the federal estate tax threshold, and unmarried individuals. Well, those are, if someone is asking, traditionally if we ask a family, okay, tell us what you own and how much it's worth, we're trying to figure out which of 3 templates, and that's what these are, your planning is going to fit in. Which document are we going to be using? Which means, essentially, that all traditional estate planning is essentially word processing if there's no counseling involved in it. So that's the whole problem in a nutshell. So what we like to have people understand is that we like to talk about personal planning goals, catastrophic illness protection, remarriage protection, creditor protection, etc. And in the creditor protection, also, and in the divorce protection area, we often tell the story, the school bus story. I'm not going to tell it tonight because we'll be telling it later in our nuts and bolts. But these are personal planning goals that oftentimes don't get covered when people are doing their planning. Catastrophic illness protection has to do with disability. If you don't know that there are options to protect your surviving spouse from third parties who could hurt them, then you're not going to use those options. Same thing with creditor protections, etc. So personal planning goals is our primary thing that we're trying to cover with clients when we do the planning. And so once we've done that, it's important for our clients to commit themselves and their family to a formal continuous maintenance and education program. And that's because, as I mentioned before, there's 3 types of change: changes in your personal situation, changes in the law, and changes in the learning that we have, that we both earned because of experience and we learned from others. And then finally, the third step, securing appropriate assistance, is all about 3 different things. One is controlling the cost. In other words, it's making sure that the people who are going to be involved in the plan have full disclosure of what it is that they're going to pay and how much it's going to cost, so that you have true peace, so that everybody has true peace of mind that things are going to go along as expected. So keys to controlling costs are full funding, meaning, and that's why we spend so much time making sure that we know what our clients own and how they own it. We want to make sure that the trusts that have all of their instructions in them actually, in most cases, own their assets, or are the beneficiaries of beneficiary designation assets like retirement accounts and insurance. And so that everything lines up with the instructions, because as I said, if you did all those instructions and then you just held everything jointly, nothing actually goes through the trust, so it doesn't work. Then, of course, there's proactive trustee training and beneficiary training, which is part of our nuts and bolts program. The proactive engagement approach, meaning we actually have a service agreement where we provide a fixed fee cap to our clients in certain circumstances, and we try to be proactive in terms of how they're going to actually engage in the estate settlement process. It's important to recognize, of course, that nobody who's a successor or who's a helper has to hire us. This is all voluntary, but we're proactive in providing a system if we do get engaged. And then, of course, the successor trustees get to hire whoever they want to hire, and they would, if they follow the proactive engagement approach, then they would normally hire us. So what is full disclosure? Well, we want people to understand the various different elements of the costs. So one cost is the cost of the documents. That's the upfront cost. But what does it cost to design the instructions and put them all in the documentation that gets signed? Then there's the cost of updating or the cost of failing to update. And then third, there's the cost after death to transfer the assets and do the death tax or estate tax returns. So those are the key elements of overall cost, which traditionally most people only focus on the first and forget about all the rest of it because they don't think it's possible to know what those other costs are. So the rest of the fees are the trust settlement and administration for both disability and death tax return preparation, preparing those estate tax returns when they're required. Sometimes there's probate services if they're necessary. But those can be fees that get involved. We try to avoid probate as much as possible. Sometimes people choose to have probate because that's the way they want to make their plan work. But typically we try to avoid that. So the reason is that when people have an estate that goes through probate, there are studies that show nationally that the average cost of estate settlement is for attorney's fees is 2 to 3% of the value of the assets. And that's really even if you have just one asset in the probate, it ends up being 2 to 3% of the total overall total. If people have a standard living trust that's typically not funded or partially funded, the studies show that the actual cost of estate settlement is 1.5 to 2.5%. But in our planning process, in our system, three-step strategy system, our theory is that the overall cost, and that includes the upfront cost, the estate, the maintenance cost, and the estate settlement cost should never exceed 1 to 2%. Notice, of course, that these three different costs are not comparable. The third one there is 1 to 2% is the overall cost, whereas the first two are just the estate settlement cost. So there's a couple of things that I want to show you. So this is the first one. This is what we show to new clients when they come in so they understand what our system is. The first option that people have is that they can choose the top 3 different things. So they do the counseling and design up front. That's their personalized plan. The cost of that is based on 0.5 to 1% of the value of their assets. And I say based on, it's not fixed at. With a minimum of $3,500 and a maximum of $12,500. And then once they've done that, they enroll in the Step 2 program in the first year. And we want them to go through an entire year in the program so they get to see everything that happens, is $995. And then after that, it's $645, and that's a voluntary fee. Nobody has to actually be in the program. But if people have been in the program and the helpers have attended the nuts and bolts program, and I'll explain what that means in a couple of minutes, our estate settlement basic fee is 1.25%, but that gets reduced to 0.75%, and that's a cap. That's not the actual fee, but that's a cap. What we call the program discount, if people have actually participated in the nuts and bolts. I'm not going to go into the variable system at the bottom because I've never actually had anybody choose that one. So that is how people understand the investment that they're making when they choose the 3-step strategy. And it's important to understand how that fits with the law practice as well. from the attorney's point of view, the upfront cost, and typically that's sometimes more than traditional planning might be, so that the cash flow is better. But we have more preparation, we do more counseling and more detailed work, so we spend more time with our clients and we have fewer clients. That's what that arrow means. We have better relationships, but not necessarily more dollars. We just, it ends up being roughly the same. Then in the maintenance, the purpose of the maintenance program is that it's priced to cover the overhead of the program and to encourage participants, to our clients to participate, so that we actually have a program that's actually operating. It also reduces stress for attorneys because we know that our clients' plans are up to date. We don't have to worry about one that comes in and it's way out of date and we have to tell the people who are doing the estate settlement that things aren't going to work just right. Those meetings are very, very stressful. And then it assures the team that they have a position in client services because there is a regular cash flow and a regular job for them to do the maintenance. And typically we get more client referrals and more clients who hire us for the third step, which is estate settlement. It can be profitable even at the lower percentages. The purpose of it gives us predictability of profit and allows for us to have successors who will take over the practice because they now know that they've got a regular cash flow and they're not just buying a bunch of wills in a vault and maybe some receivables. It's actually a program, it's a business model, and that's what that looks like. So you can see that there's a kind of an interrelationship between the three-step strategy and how our practice actually works. So those are the two kinds of things that we like to make sure that people understand. So in order for you to have appropriate assistance, you need to, in order to have true peace of mind, you need to know, will things go smoothly? Well, in order to do that, you need to know that we're the ones that, if the helpers are going to choose us, they need to choose us because, we're the right age, we have the right experience, our personality matches them, our values matches them. If they don't match in those, then they're not going to pick us. We have some commitments that we do ask our clients to be involved with, and that is, will you make the necessary commitments to get your helpers to attend the classes? Will you discuss the estate settlement and estate planning with them? And for the people who are involved as helpers, will you honor the process? So those are important things to remember that we have a stake in the planning for. So those are the 3 steps of the 3-step strategy, and that is the basic presentation that we make to new clients when they come in, so that they can understand what how our system works, how our planning works in our practice. So the third part of our program here is what we call the werewolf story, and it's a short one. It was developed by Richard L. Randall, who is the chairperson of the National Network. He's the one who actually developed the 3-step strategy back in the 90s. And he's the one that gradually, as time went by, many network members began to realize was the right way to practice. And I will tell you, the first time I ever heard about it, I came back to the office and said, gee, I don't think I can ethically practice any other way to offer this option. So that's how it works. The National Network has basically adopted the 3-step strategy as its business model. And so in order to understand what it's like when somebody dies, we have this werewolf story that was developed by Mr. Randall. So how we like to ask people, how do you like horror movies? When people are in an audience, some people like them, some people don't. Most people are familiar with the basic plot of a horror movie. but most people don't think that they're likely to star in one. And that's the truth. They are. So here's the background. You know, in any werewolf story, you have a hero who is going along. He leads a normal life. He's got his friends. He's got maybe a girlfriend. There might be a romantic storyline going on. Typically it's a he. It could be a she. I remember the vampire killer stories, but we're talking about werewolves here. So we all know typically the plot and the background of a werewolf story. And then after we begin the story and we're introduced to all the characters and we begin the storyline, we understand their background. The next thing that happens is that there's an attack. The werewolf attacks the hero or the heroine of the movie, and then we know we have a problem. And the attack results in our hero becoming a werewolf. So what does that mean? Well, in our field, in the field of estate settlement, what happens when somebody dies is that their loved ones now have a tremendous loss. And they go through a year of recovery from that loss. It's the mourning period. It's the worst possible time for them. They have all different kinds of things that happen to them, and they go through a number of different stages of the mourning process. And the first stage is anger. And who do they get angry at? Well, here's our cast of characters. We've got the survivor. That's the person who has had the loss. And typically in the werewolf story, we have the friends who knows. These are the ones who claim to be the insiders. They know all the rules. In the werewolf story, they know all about what happens with werewolves. And then there's the advisors who advise the hero about what they're supposed to do, or the survivors about what they're supposed to do. And then we have the loved ones, who are the people that the decedent really cares about, or that are basically involved in this problem. So how do you kill a werewolf? And it's funny, I understand that when this question gets asked in large groups, people usually say that you need a wooden stake and that kind of thing. And the answer to that, of course, is no. That is a vampire. We're talking about vampires here, and of course you need the silver bullet. So what is our silver bullet? How do we bring this person who is going through this horrible ordeal of having lost the person that they love or the person that they really care about, and now they're going through all of these various different problems that they have to get through. So how do you get them through that? Well, it's important to be prepared in advance. So there has to be advanced preparation in order to be able to assure this person that you know what's supposed to happen, you know what the process is, and you're prepared to do it. And so, excuse me a second. Sorry for the interruption. So it's important to be prepared in advance for this experience as a helper, because, for example, typically the surviving spouse is going through this year of recovery. So who are they going to get angry with? Well, in our experience, the person that they got most angry with is us. And that's very understandable, because we're the ones who are actually running the show, and the person who's the survivor doesn't remember everything, tends to get suspicious, and gets very angry particularly with the attorneys. And that is the point at which the helper's job is really kind of to bring the person through that period of time and kill the werewolf. Get them, set the proper expectations about what the process is, remind them about what the process is, and help them understand that they're going through an emotional experience that they really don't have a whole lot of control over, and that it's very understandable for them to be going through these various different stages. So it's important to be able to be prepared in advance, and that's what our Nuts and Bolts program is, so that the people who are the helpers will be able to have proper expectations, and will be able to help the people who are going through a year of mourning or more understand what the process is and how things are supposed to go. So that's our trustee training workshop. That's our program. I just want to do a quick summary about the trustee training workshop. Remember that it's really not about the documents. The really important thing is really about what people do after someone dies. And it's very important to understand the parking lot rule, which is that if you've been to a presentation, oftentimes the experience is that you can leave the meeting and go out in the parking lot, and by then you've forgotten 3/4 of everything that you heard in the meeting. That's the parking lot rule. And so our goals are and everybody remember our firm name, remember these few things, what the firm name is and what our contact information is. Remember that there is a process. It's the process that produces the results, so we need to follow it, and we need to be dedicated to following it. And we want to give you an idea of the types of issues that you're going to deal with, and we want to encourage your interest in the planning and participation in the program. So remember, the first thing that happens, first thing to do when something happens, when somebody dies or becomes disabled, call the law firm. Locate the client's blue book. That's their basic operating manual for the Step 2 program. Locate the client's red book, and then relax, because we do have a dependable process that you can follow. So let me open this up to questions. Does anybody have any questions? Well, I guess we don't have any questions.
I guess you did a good job, Frank.
None here. Good.
All right. Well, if you have any questions, please feel free to contact us or contact me. Happy to talk to you. And look forward to seeing you at the next Nuts and Bolts session. Have a lovely evening, everyone.
Thanks,
Great.
Frank.
Thank you.
Frank.